before I speak about merit application, my lord, the name of petition number 2 and 6 may be deleted. 2 has already been engaged. The name of 6, then inadvertently
Name of
type 2
petition
and
number
6. 2 and 6 in the content
Right.
petition.
who has filed?
2 and 6, my lord,
Yes.
may be deleted. I'm filing a memo. 2 has been engaged and the name of petition.
The counsel for the petitioner submits that the petitioner number 2 and 6 are not interested in pursuing the instant matter.
Two thousand 24,
Page.
19-1,
Page.
order, my lord, order sheet,
Oh,
order
this-
number,
in
order
the
19-1, 2000, yes, content picture. Because they have come in writ appeal, this court directed to wait till the
Correct. Now what is happened to the
happened, my
appeal?
lord, the appeal was dismissed.
Where is that order?
Well, that is there in the note sheet is there, and also filed an affidavit also.
So
That is on the
have you
record.
gone there?
Yes, Milord. We have to. It has been dismissed, Milord, in February.
SLP dismissed?
Not SLP.
No,
Milord,
here,
writ
Milord, writ appeal.
Writ appeal, Milord.
That is true. What
Yeah.
about SLP?
SLP we have not filed as of
We have
yet.
not filed.
So, Milord, we have to comply, Milord. Some time may be granted, but we have to comply.
What?
Milord, some time may be granted for compliance, Milord. No SLP has been filed, Milord. In February of this year, Milord, the writ appeal has been dismissed.
How much time you want?
Let me give some time.
Yeah, sir. You're asking how much time? Why don't you tell?
It's at least 2 months time, Milord, because a number of steps have been directed to be taken in the writ petition.
The uh,
Time for the petitioner. The opposite party has not complied the order dated 21st
First
June.
thing is, what is the nature of the order, sir, and
Not
what
net-
page?
Arising out of matrimonial affair, my lord.
No, sir, at what page?
Page annexer, page 10,
Page 10.
my lord. Para 5. Since time as granted by us has expired and the correction has been made today, the respondent is directed to pay the permanent alimony to
3
the extent
lakhs.
3 lakhs. Time was fixed
Now,
for 4 weeks.
notice has been given to him.
Notice has been given out of 3 lakhs. Only 50,000 has been paid and taken time one
No.
after another.
Notice of the content was given.
My lord, appeared
Somebody appeared. Who appeared?
Mr. Brahmachari, Anup Kumar
No,
Brahmachari.
Mr. P.K. Mahanti.
And Anup Kumar Brahmachari name is also there. My lord,
Yes.
on last date, 22nd December.
What is doing?
My lord,
What your husband is doing?
businessman.
Ex-husband.
Businessman.
Businessman.
My lord.
Have you disclosed the bank account?
My lord, she has already married to another lady.
No.
Sorry?
Here, they're asking, do you know about the details of his bank account?
I have already given bank account. No, I have no knowledge regarding bank account
Sorry?
of the husband. I have no knowledge, my
I
lord.
have given a bank account and I have no knowledge of a bank.
No, my lord. Bank account of the petitioner, present
I
petitioner.
am asking the ex-husband's bank account. So
My lord,
that we
I have
can
no
see
knowledge.
the amount from there.
My lord, I have no knowledge.
Then tell me that from where you will realize the money. What is the source?
Why don't you try to find out if it has been transferred from his account?
If
Fine.
let it come next week, I will provide this.
I pledge your lordship, my lords. My lords, I am permitted to appear virtually, my lords.
Oh,
So this contempt was filed, my lord, non-compliance with this honorable court's order dated 22/9/2021, passed in WPC number 5454/2027, my lords. As per lordship last direction, already they have complied, my lords, in the meantime.
they have complied.
Yes, my lords.
Yes, my lords.
Would you like to pursue?
So then we can dispose of the contempt.
Yes, my lords. Yes, my lords. Nothing left, my lords. Yes, my lords.
Right. Right, please, your lords.
What is the direction, madam?
On 20th
Can you give
February
me a page number?
2026.
Can you give me a page number?
Page 11, my lords.
I am talking of the order passed by this honorable court on 20th,
20th?
that is
20th?
20th February 2026. And order is in page 11.
Oh, have you displayed?
Dil-
Uh, billboard in
Yes,
every
please.
department,
My lords, we have filed a compliance affidavit which is at flag B.
flag.
B, my lord, B for Bombay.
Okay.
My lords, there, my lords, we have annexed, my lords, certain documents. My lord, the first annexures A by 1 and B by 1 are communications by the government to various organizations and institutions which are run or financed by the government as per the order passed by this honorable court. And C by 1 series, my lords, is, my lords, what we have
Yes.
C by 1 series, my lords, which starts at page 18, internal page 18, my lords, is the confirmation given by various departments and organizations, my lord, institutions also, that billboards have been set up.
Doesn't
Page-
have the No copy has been served on
Flag B. My lord,
You
second
have
copy.
not served the
I'll
copy.
serve a copy. My
What are you talking?
lord, I'll serve it today in
Huh.
course of the court.
This is not expected.
Well,
You will sign the affidavit of compliance and the contemna
My lords, I'll serve
will
it.
not, the petitioner will not be able to know.
Yes, my lords. My mistake, my lord, I'll serve it in course of the day, my lords. In course of the day, my lords, I'll serve it.
Item number 5.
The SLP dismissed in 24/7/25, but have only been granted provisional pension. After SLP dismissed on 24/7/25 for grant of pension.
24/7/25. Okay. Then
And after issuance of contempt notice, they have only released my provisional pension, but final pension is not been till date.
yes, sir.
My lord, we have filed an affidavit, my lord,
Yes.
on 6/5/2026, my lord.
Where is that?
My lord,
Paragraph 6.
that is at flag C, my lord. And page 3, paragraph 6.
Paragraph 6.
What is the final pension?
My lord, that is, my lord, it was filed on,
The provisional pension
yes.
you have paid.
it was filed on 6/5/2023, my lord. Till that date, my lord,
What?
but till filing of this affidavit, my lord, provisional pension was sanctioned. Now there is further development, my lord. They are going to finalize the final pension, but I have got the information, my lord.
That arrear pension which you have paid is calculated at the rate of provisional pension or normal pension?
Provisional pension.
That is provisional pension.
Arrear is also provisional
Yes,
pension.
That's been granted 2
The
weeks.
SLP was dismissed.
This
Yes.
is till 24/7/25. After dismissal, they release the provisional pension.
Number 6.
Lordships, Mr. Swine has some. Lordships, Mr. Swine has some personal difficulty to appearing this matter. Kindly come up next week.
So where you got 6? Oh, you have opened the wrong list. I think it's only 5.
Nice.
Yes.
What is the review?
Sir,
Review of which order?
sir, excuse me, sir. Lordships, the arguing counsel will be appearing next week.
Sorry, this bench is sitting. There are 2
Lordships,
bench which are disruptive for this.
I'll get
My
Lordships, but
sister is sitting in a single bench. I have to discontinue the regular division.
I get Lordship, it's a personal
No.
difficulty.
And this matter was listed earlier. You had a knowledge. You'll have to. Which order is sought to be reviewed?
Lordships can be
We will
start
set it
sir,
right. We will
next week,
not
Lordships.
keep the matter. Because earlier occasion you have asked for a time.
But sir, there's some personal
No.
difficulty, Lordships. Please
No,
kindly
you are engaged in the matter.
Lordship, my senior is engaged.
Sorry, have you filed a Mogaladama? Signed a Mogaladama?
Lordships.
That's your responsibility to argue.
It's instruction for my senior Lordships.
No, sir. Sir, it cannot be done. What has happened to it?
Just consider Lordships.
Eh?
Please consider it, Lordships.
What consider? Tell me.
We are asking what is his problem? Why has he not come?
It's some health issues. Lordship, maybe he is not appearing today.
High Court 2022 Lordship will find the counsel was different.
Yes.
The arguing counsel is different. Arguing counsel is different.
That is why when the arguing counsel comes, he has to answer that first.
Yes.
So we change in the meanwhile.
Two weeks.
Grateful, Lordship.
Item number 7.
On behalf of my lord, A.K. Patel, my lord, is seriously ill due to fever, my lord, high fever. He did not come to from Delhi, my lord.
Fever is serious.
They told me that I am not able to argue because I am not feel well.
Since when he is seriously ill, sir?
So 3-4 days seriously. They are
He was seriously ill on 3rd May 2025. It's okay. Then
my lord,
log 13 to 2026.
my lord, last occasion he appeared by
So
BC.
he was also ill on that day. What to do?
My lord, last occasion he appear in VC. Honorable Court directly come to open court. But today, started telling me that my health is not well. So fix a last date and I'll positively appear. Last kindness, my lord, last Friday, my lord.
I was there for a pretty long time, 19 years.
Yes, sir. My lord.
This is well known to me.
A humble submission.
So my sister was there. Friday, he's coming from where?
Delhi is my lord.
Huh?
Delhi, my lord.
Friday.
My lord, kindly fix up that. Fix up that, my lord. Fix date, my lord.
Friday.
Next Friday, my lord.
Next to
Week,
next.
week.
Which Friday week? How like 70?
Item number 8.
Review of which order, sir?
My lord. Writ appeal number 1981 of 2024
Give
was
me a
disposed
date.
of.
Give me a page number.
Sorry, my lord.
Give me a page number.
Yes. My lord, it starts at page 219.
290.
Yes, 219
Just
of the
give
writ.
me 1 minute.
So, my lord.
Too bad. What is this, bro? What is this? Sorry, review.
My lord, if I may be permitted just 10 minutes before going to that, what has happened?
You just
The respondent, my lord,
yes,
was
under Rule 48, you
Yes.
are entitled to initiate a disciplinary proceeding if even after the attainment of superannuation. There is no difficulty.
My
The
lord,
question was whether the board was consulted, and
Yes.
therefore you argued the matter that the consultation of the board or approaching the board is merely a directory in nature, not a mandatory provision. It's
My lord,
not a mandatory one.
my lord,
And
may
you
I,
relied upon this Haryana judgment.
my lord, may
The
I,
court has said no,
why,
board has to be consulted.
Yes, that is why I filed the review, my lord. When this judgment was passed by this honorable court, my lord, the only ground on which this honorable court interfered in the writ appeal
Correct.
was non-compliance of that regulation 48 of the pension regulations, whereby it was held that it is mandatory. And the other observations of the honorable single judge confirming the punishment imposed by the disciplinary
That
authority
has
was
not been
upheld.
interfered with.
Yes, my lord.
There is no nothing, but it simply says that this is one of the important
Yes, my
aspect.
lord.
You
Yes.
have to take
Yes.
recourse to it.
Yes.
So naturally, everything has to fall. If,
Yes. Why we filed the review, my lord?
yes.
When this order was placed before the board for passing orders afresh on this point, on going through the materials, it was found that the board had been consulted and it had given approval. It had given approval prior to passing order of punishment, which has been annexed as to page 247 of the review petition.
Okay.
That is the sole ground on which this review has been filed. So what I was praying before your lordship, as the honorable single judge order
I
has been confirmed.
understood.
Well,
I got your point.
But
Now the question is that why you could not produce that particular the resolution?
yes, for that I am, my lord, if your lordship kindly see page 35.
Where is the averment on a due diligence?
My lord, what I wanted to point out on that aspect, kindly see page 35. In the writ application, let me show you, lordship, what led to this, my lord, inadvertent error. Kindly see page 35.
Oh, it is a case of an error.
Yes, my lord.
Yes. No, I was
Kindly see
thinking
page
otherwise. Anyhow.
Yes, my lord, I am reading out paragraph 15 of the writ application filed before the single judge. That the petitioner respectfully submits that according to first proviso of sub-regulation 1 of regulation 48 of the pension regulation has not been followed, as no letter to that effect has been communicated to the petitioner by the bank. His case was, my lord, that under this regulation, whatever approval is there has to be communicated. Now, my lord, may kindly see page 58 before I leave. What is the reply I have given to this? What is that regulation? Whether that requirement is there or not.
Correct.
Kindly see page 58.
Yes. This is your pleading.
Yes, I have pleaded that the writ application.
Where is your pleading or your stand to paragraph 15?
Yes, yes.
What is your stand? This paragraph 15 is
yes, page 8
of a writ petition. Paragraph 15 of a writ petition you produce.
My lord, page 110. 110. 110 is my reply, my lord.
This is the writ petition. Yes. Where is your counter affidavit?
In the counter affidavit, page 110, I am deleted.
Please.
Paragraph 13. Where the error crept in, I wanted to show to your lordship.
Yes.
Paragraph 13, your lordship may see page 110. That in reply to the amendments in paragraph number 15, it is humbly submitted that they need no reply as no letter is required to be sent to the petitioner as per regulation 48 clause 1 first.
What is this reply?
My lord,
what is this reply? He has specifically averred that you have not followed the first proviso of sub clause 1 of regulation 48.
My lord, he has not sent me a
no letter to that effect has been communicated.
My lord, may kindly appreciate
that. You have said
again.
No need to need no reply as no letter is required to be sent.
My lord,
he did not say the letter.
Yes, my lord. That is his.
Sir, my understanding of English language may be bad. Please.
No, my lord. May I read it? 15 again.
Please. I am reading slowly.
My lord.
That the petitioner respectfully submits that according to first proviso to subclause 1 of regulation 48 of the pension regulation, that is wrong English, has not been followed. That he says that this proviso has not been followed.
Followed, my lord.
Why he's presumed that it is not followed? Because no letter to that effect has been given to him.
Yes.
So there are two catch. One is he says that it has not been followed, and why this impression of non-adherence has come to him because no letter has been given to him. So twofold. You have to deny first you have followed it.
Yes.
I have followed the entire procedure, and then you can say that no letter is required under that proviso to be said.
Yes, that is why.
Where is your reply? In your reply, you have said, humbly submitted that they need no reply as no letter is required to be sent to the such and such. What about the following?
My lord, what arises the question whether the requirement is two-fold or single-fold is answered in page 58. That is why I wanted to draw your lordship's kind attention. What is that regulation? Kindly see, my lord, page 58.
Sir, again, then I will be reminding you of the jurisdiction of review. The review is not meant for a rehearing of the matter, to consider rehearing, going into the voluminous document, and then saying. Sir, question is, again I am saying, we are testing the judgment or the order on a very strict parameter when you have approached under Order 47 Rule 1.
Yes.
Just show us what is the you are saying that no, the board was already consulted. I just wanted to know two things. First thing is, did you disclose this fact in your counter affidavit that the board was consulted? Then I can understand that the document was there. The bench did not notice that. Then it is an error apparent on the face of the record. No problem. If you have not given, I am talking in the light of the judgment rendered by the Supreme Court, AIR 1964 Supreme Court, Tungabhadra. I am just talking what the Supreme Court has said. Nothing new. And till date, that judgment is invariably followed till now. Then if you say that though it was not within your knowledge, question of due diligence would come. That is a second part of the review.
Lord, I have two judgments on that. Just for a minute. I will answer that, my lord. I have got the judgment.
What judgment? Tell me what is the
review, my lord.
Tell me what?
Whether under this judgment,
tell me what judgment?
State of, my lord, 93 supplementary 4 SCC 595. S. Nagaraj and others versus State of Karnataka and another.
What is there in S. Nagaraj?
My lord, this is a, my lord, where it has been stated an order passed by the Supreme Court under a mistake held can be recalled.
Again, I am saying, sir, this is a question of a mistake. I know everything about it.
Mistake, my lord. This is a
that means there is a quoting of a legal maxim, actus curiae neninem crebebit.
Yes.
That the act of the court shall not prejudice any litigant. If a mistake is committed by the court will rectify its mistake. Whether it comes within the purview of a mistake. Mistake means there was something there, inadvertently something has been written. If the court has interpreted correctly, incorrectly, that may be an erroneous decision. You can go and correct it higher up. You can't say that it is a mistake or an error.
But why I am saying error on fact of the record, in his writ application, he has filed the regulation 48 as an annexure.
So
if your lordship reads that,
the court has taken note of Rule 45, Regulation 4048.
Yes, my lord, I am not on that.
Note. If the court says that I read it in a different manner, it may be an erroneous decision of the court. It can't be said to be an error apparent on the face of the court.
Why I am trying to bring it within that is if I may be permitted to read that regulation, my lord.
I think you have not read our judgment which we dictated.
You have to show
again reiterating that judgment.
That it is show the judgment where it's mistake of the counsel. It is your mistake you have admitted that you could not bring to the notice of the court. It is not mistake of the court.
I will bring, my lord. Certainly it is not a mistake of counsel, inadvertent error, my lord. It was from Sambalpur region. It was pleaded and from Calcutta it was sent. So this thing, why I wanted to show to your lordship,
sir, then you'll have to take shelter under any other provision of the review. Under what grounds the review are allowed? Tell me. Let us go academic.
My lord,
let us go. Don't take it amiss.
No.
Please, let us go academic. On what grounds the review?
My lord, error apparent on the face of the records.
Correct.
One is there, due diligence or new facts which could have new facts.
No.
New facts has to be linked with due diligence, my lord.
No,
which are not there.
The word fact is not used.
Lord, I am not having the CPC.
Yes, CPC, give it, take the top of it.
There is one more also. You just
and my lord.
Other substances. Two facts.
I should have got CPC. I'm sorry.
Please. Order 47, Rule 1. Please read.
Application for review of judgment. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. By a decree or order from which no appeal is allowed, or by a decision on a reference from a court of small causes, and here, my lord, and who, from the discovery of new and important matter or evidence.
Correct.
Which
so facts where it comes?
Yes. That is what I
Facts, no, matter and a material or evidence. There are two portions, material or evidence.
My lord.
Does not talk about fact.
My lord,
Fact is distinct from a material
lord.
or evidence.
important material evidence usually flow from the facts of a particular case.
No, not necessarily.
Because, my lord, what can be facts? Facts can only be
Sir,
some documents, some pleadings,
No, sir.
which were not
No,
there.
sir.
They are all
Suppose
documented.
I'm giving you. Suppose an issue is one. The court decided something else. The issue was not there. It's extraneous or alien to a dispute or a subject cause of action. Will it not be a matter in dispute?
My lord, may I complete it because I am relying on another limb of this man.
These. What limb?
The third limb, my lord.
A third limb is very interesting.
Or on account of some mistake or error apparent on the face of the record,
Correct.
or for any other sufficient reason.
Now, what you understood by it, is it an apparent on the face of the record? Because the record is silent. The record is silent whether there was already a decision taken by the board before the imposition of the penalty.
Yes,
the record was silent. Show me from the pleading.
Yes,
show me from one document in the
yes, that is what I'm showing, Your Lordship.
that you have disclosed that yes, the board was consulted.
I am on a slightly different aspect before going to that, if I may, my lord. One line, page 58, that is an annexure to the writ application relied by him, provided that the board shall be consulted before any final order passed. Here, my lord, the word is consultation. The word is not. That thing, that regulation has been annexed. In that regulation, there is no whisper that whatever is the board's approval has to be communicated to him. And in page 35 of his writ, his specific plea was that this regulation has not been followed because it has not been communicated to him. That is the reply to which I gave, saying that it is not necessary. That is where the error and mistake arose, my lord. Sufficient reason which has been stated in Order 47, the third and fourth.
That's all. So let us start the dictation. That's all. Then we will consider this aspect and we'll say that what it is.
Because, my lord, if your lordship would
Yes.
see, kindly see.
So which ground does your case come under?
My lord, it starts from page 8 where I've given
No,
the
no.
though I have not specifically taken the
Asking
grounds.
you, Mr. Mishra, just tell us because we have limited.
Yes, yes.
Why you have not taken a ground? The review has to be filed in the same manner as the appeal is to be filed. There should be a memorandum of appeal or a memorandum of review.
No, my lord, we don't file a here not as a memorandum of review as
Why?
it is.
That's a code of procedure. It says so.
My lord,
It says so.
under the High Court rules, my lord, we generally file it in this manner, the review. But
High
appeal,
Court,
of course,
High
we
Court
give
rule
the
says that it has to be filed in this manner. No memorandum to be filed.
no, not in the form of a memorandum, my lord.
Why not? What the CPC says it is to be in the form of a memorandum.
My lord, CPC says, my lord, but your lordship knows these proceedings are emanating out of writ proceedings. CPC.
Oh, CPC does not. It applies mutatis mutandis, I believe.
My lord, I would humbly beg to differ. There are many
Beg
decisions
to
that
differ.
there are many decisions, writ proceedings, my lord, CPC
I
doesn't
can give
apply.
you many decisions which says that the principles akin to the CPC will apply.
Yes, my lord. That I do not
So-
dispute that, my lord. That the principles akin to will apply.
So
Your
why
lordship is
not?
correct.
Why not memorandum? No ground is made out.
My lord, on from page 8, I have given para-wise, I have given the grounds.
What are the grounds?
My lord,
Apparent mistake. First thing is you say mistake
my lord, I
and
say,
error apparent on the face of the record. That's all.
my lord,
No other ground.
my lord, the ground is
Re-
error apparent. Why? Because,
I did not ask you why.
my lord,
I am
Yes.
putting you a very specific question.
yes,
It is founded on a mistake apparent on the face of the record or an error apparent on the face of the
Yes,
record.
ma'am.
That's all.
yes, ma'am,
No other ground.
my lord. And any other sufficient reason, my lord, as given in order 47 rule 1. Any other sufficient reason as given in order 47 rule 1.
Good. Then I will say that how the Supreme Court or the different high courts have interpreted the third provision.
My lord, then if your lordship can grant me one adjournment, I'll try.
No adjournment, sir.
Because this is coming after a long time, so I have matlab on facts and part of law I have covered, one part I have not. If your lordship permits, of course, my lord, this is a break bench.
Provision is coming before us. Scene 5.
2026, Lordship. 103, Lordship. Sorry, 103.
I was wondering that there is no order passed.
Lordship, 103, Lordship. Sorry.
Yes. Any amicable solution?
You have some instructions.
Yes. I have,
Either this way or that way. Some instructions you should
yes,
have.
Milord. Only one instruction I have.
Yes.
I'm sorry, Milord, I am having one problem. It could not be.
Merits it can be argued, Lordship.
Then it has to be argued early.
Lordship, may I know?
You argue?
Lordship, may I know what is the instruction, Lordship?
No.
Because
No.
It is they have
Not.
shown
They
it's
simply
not
said
possible.
I am not going to accept.
Not possible.
Not possible.
Lordship.
On 13.3. That is already there.
17 July.
Sir, I am doing in this fashion, so they give already a date.
Increment to continue.
If there be any, just if there be any, shall
That
continue.
is why my lord moved to the
Yeah.
applicable settlement. My lord, on the last occasion, the petitioner submitted that he does not want to continue with the work. And he only want to
No, do not read. This says they have not
State
accepted
ego,
it.
lordship, state ego.
They have not accepted it.
To contempt, my lord. On the earlier occasion, the state had sought time to file
You
and
find your affidavit?
No, my lords, I have not filed the affidavit, but I have received instructions, my lord. But I'll file the affidavit.
Mr. Roy, you should know the gravity of the
Well,
litigation or the proceeding.
Well,
It is not a casual proceeding as you perceived. It is a contempt. You are in contempt.
yes, my lord.
You have to show some kind of a seriousness, not on the instructions.
Well, let's make all the matter next week, my lords.
No, you can't do it in this fashion.
It's actually yesterday night.
There is a very casual exercise which has been shown.
On 30th January 2026, we ordered to file purposes within 2 weeks. We are in July. Should we order for personal appearance of the contemner?
Let's give me one opportunity, my lords. I'll file it by next week, my lords. I'll file. Actually, yesterday night I've obtained instructions.
And 3 months time was given by you, brother.
Give me for filing of the affidavit, my lords, give me some time, my lord. Actually, my lord, this has not been complex, to be very honest. There is a difficulty, my lord, that we are facing. If my lords will see the order, which is at page 14, my lord, the proceeding pertains to the year 1970. And the order passed by this honorable court itself says that the record is to be traced out. My lord, we have tried our level best. But
No,
till now, my
if
lord,
there was any difficulty, the state should have moved an application for extension of time.
yes, my lord,
That
my
was
lord,
not done.
for that I'm playing 1 week time, lord, because till now, my lord, I'm
At this stage, you will be praying for modification of the order.
not for
Or
modification.
compliance to
No,
file
Lord, we are
request.
praying for extension of time to comply, my lord, because now we are scanning. We are scanning, my lord. We are hopeful. And one other thing, if I may request, my lord, if the petitioner has any documents pertaining to that proceeding, if he'll be kind enough to, my lord,
Sir, you could have written a letter to him that this is what a situation which is
Yes.
prevalent. You must show some kind of a proactiveness in compliance. You have not written a single letter since 9/1/2023.
let's we
The
are,
contempt application when it came to be filed, then you are raising all these questions.
let's we are searching, my lord, fervently.
They are searching, then you could have approached them.
That we are not.
That though there is a direction, we are unable to locate the records. Please supply me all the relevant documents which you have in your possession.
That's what, my lords, I wanted to.
That you do not know.
Because I wanted to request my learned
No,
friends, my lord,
now request
because they have not.
after 30th of January.
But they have tried their best.
No,
my lord,
sorry,
but
we can't accept this kind of a. It's a
Then my lords,
complete
we-
apathetic attitude
then
which
my
you have
lords,
shown.
give me some little
You
more.
have little scanty to the majesty of the order.
Lord, because the record pertains to the year 1970, my lords. That is the whole problem, my lords. And my lords, it belonged, that time there were not so many tahsils. It belonged to the mother tahsil, Bhubaneswar tahsil. It has been bifurcated into a number of tahsils now. So in transit, my lord, it is there somewhere. So we are searching, my lord, fervently searching, and we are hopeful we'll find out.
Yes, this is what we. Post of a Tahsildar there.
Yes,
Huh?
Yes,
She is still holding.
yes.
Same officer is continuing there.
No. Present not necessary. Priti Purna.
The person I spoke
I
to,
am asking you, Priti Purna Mishra
No, no.
is still continuing.
no, my lords, because
Otherwise,
I spoke to the tahsildar today morning also. He was a male person, so it is not the same officer.
what?
Sir, do you understand our
Yes,
query?
yes, yes, madam.
We are asking whether the same officer is continuing as Tahsildar Chutney or not. You said yes. and where the state council saying that some male officer attended his call.
With regard to that, I will take instruction. Milord.
Then, without taking instruction, why you are making a wrong assumption?
We'll have to add
Yes.
the new incumbent. Where is the Pritiparna?
Let's
You appeared.
where she is presently, my lord, I'll have to take instruction.
Sorry,
But if my lord will give me some more time, my lord will comply. My lord, we are doing a level best, my lord. By name, my lord, I can take instructions.
You also do not know.
My lord, I have no asked him. Asked him.
Give the name.
Okay, I will take.
The direction of this honorable court has been complied. Yes, ma'am.
What was the direction?
The direction was given to the State Department to issue a demand notice. Following, the direction was given to the State Department to issue a fresh demand notice, my lord.
When court will issue a demand for conversion fees.
Yes, ma'am.
Yes, my lord.
That has been.
That has been issued, and we have also made the payments.
Let's we filed a compliance affidavit. That is at flag B.
That is by a judgment and order dated 1/5/2023. The demand raised by the authority was quashed and set aside, and a direction was passed upon the additional land officer to forthwith issue demand for conversion fees on the basis of the order dated 22nd April 2010. Within Reinstatement of the petition to the contract is simply. Okay. Mr. PP.
And earlier another
SP Mondal.
Earlier another contribution was filed.
Another contribution.
Yes, it was disposed of. It was disposed of. Well, kindly turn to page 29. Arising out of the steps in the judgment.
How further contempt would lie?
Yes, ma'am. Well, kindly come to page 29. My lord passed the order on 4/4/24. It starts at page 29 and the relevant portion is page 30. Yes, ma'am.
Past content was disposal, given direction if not complied, should be complied with.
No.
Yes.
No. Well, kindly count page 31. On merit.
It has been complied with.
Sir, please come to page 19.
19.
Yes, that was the first content. Please come to page 19, Annexure 3.
Yes, madam.
That was the first content.
Madam.
Wherein direction was if not already complied, should be complied with 3 months.
Yes, madam.
That was duly communicated to you by Annexure 4 series. Thereafter, the second content was filed.
Well, kindly see.
Item number 4.
Same matter.
Yes.
Item number 5.
Your Lordships have complied with the order.
Is the Lordship? My Lord, item number 5, praying for an adjournment, my Lord.
You ask for an adjournment.
My lord, then pass over my learning.
So what, senior? They should pay some attention to this matter for this bench. Never expected. I have not come across with this. When a special bench is sitting, adjournment, he is on legs with, before the another court. And that is also not a ground under the Code of Supersedure. Are you aware? Who is the advocate in record?
Vivekananda Bhuya, senior advocate, my lord.
Copy received.
No.
Copy, copy of the IA on state.
IA copied it.
You have filed the IA. The prayer to modify, we recall, we modify, we clarify the order date 3/2/2023 in terms of judgment dated 70/12/2020 passed in the SLP.
Copied it. It appears that that the interlocutory application has been filed by the petitioner seeking clarification / modification of the current order of the
The annexure 1 is the order. The operative part, your lordship, page 14, your lordships.
Yes.
Page 14, your lordship. Is annexure 1, page 14, paragraph 8 is the operative person, your lordship. The writ petition is allowed, and annexure 1 is passed to the extent of the levy penalty at the rate 0.20%. The opposite party are further directed to release the withheld bill value of the petition.
Has it been released?
No, sir, your lordship, that has not been done.
Will the state have
Was it communicated?
Yes, yes, my lord. Thereafter.
Communicated?
Yes, yes. Thereafter.
Any
Yes. Annexure 2
is directed?
Yes, I communicated annexure 2. Annexure 3, the chief engineer also recommended government, but till it has not been.
Notice returnable after 2 weeks.
Non-compliance of order 14/5/2024. Annexure 1, page my lord 7.
Page
7, and a relevance portion, page.
What was the direction?
Direction, my lord, 46. In the result, both the writ petition are allowed in part of contest, but no order as to cost. Consequently, the order impugned in this writ petition stand quash so far as it is related to quashing of the corrigenda and the direction for the not to provide age relaxation to in-service candidate. But rest of the direction in the impugned order of the tribunal need no interference and hereby confirmed. That in the meantime, the petition filed one way before the State Education Tribunal under Annexure 2, my lord.
No, this is what the order is. Then
First, the petitioner filed one way.
page 46, kindly see there. Also, I am looking at the page 46.
Yes.
So there are twin things. Something the order is quashed and the partly it is affirmed.
Yes, my lord.
So they are aggrieved by the portion which was affirmed by the division bench.
Yes.
Are you aggrieved by that portion?
No, my lord.
Then
My lord,
then what for the contempt?
my lord, agree, my lord, part of tribunal. In the meantime, State Education Tribunal abolish.
and affirm the other portion of the order. No difficulty. Right. Now the administrative tribunal of the state is abolished. The matter has all been relegated to a single bench. Is it? If you make a complaint that the remaining portion of the order, which was not interfered with by the division bench, that has been violated by the LS contempt. Then the question is it so or is it not so? This contempt is based upon which portion of the order, which is affirmed by the division bench or not, which is affirmed by the division. Now then the question arose whether the contempt would lie to a division bench or it will go to a single bench. That's the only thing. Single. It will go before a single. Yes. Because I am stuck with my own judgment. There, a special bench judgment, 3 judges bench judgment authored by me. Mere affirmation is not to be construed as the merger of the order and the division bench will take up. It has to go to the single bench.
Ultimately, for operation of the tribunal.
Because now the tribunal is abolished.
Yes.
All the matters has been transmitted to a single bench to entertain. So it will be deemed to be an order of the single bench.
Yes, sir. But there are other developments that has taken place. If you can explain it before the next. Yes.
After 27 Millard, the state preferred SLP and the SLP posted on 27th of this month.
Yes. It is informed to this court that the special
Six also same. 6 also same. Both 3 and 6 kilos.
Item number 4.
The order has already been complied.
Complied.
Yes. Order is complied with. But
yes,
order is complied with.
Yes, Your Lordship. I'm appearing on behalf of the petitioner. It's complied with.
Same order. Next.
Item 7.
Hello. Order dated 7/5/2024 has not been complied. Has not been complied. Not. This is a 7/5/2024 order. What is the direction? Direction is that representation. Have you not disposed of the
Your notice has to go, Millard.
Only notice
has to go.
Only notice has been issued. No demarcation procedure. Service you effect. It's a contempt application. Returnable 2 weeks.
State preferred SLP and SLP dismissed, and now order is complied. Yes, complied.
Item number 10.
The OP number 6 enclosed a certain land above the DT. Order was by this honorable at 9, page number 9. Order was there to take to consider the reputation. Then a contempt application was filed. First, and another contempt application was filed.
I am asking you, sir, the direction was passed to consider, shall examine by the Tehsildar your representation.
Yes.
Giving an opportunity not later than a particular time and the order to be communicated. If you are feeling aggrieved again, then you can.
No, thereafter one contempt application was filed.
Let's page
This
10.
is second complaint application.
Page 10.
Under what provision of law second contempt application lies?
I am coming to the question.
I am asking you, sir.
And
what provision
first
of law?
contempt
They
application
said
was
to this honorable court that the Tahsil has taken a decision. But that decision, in fact, Tahsil has taken a decision, but that decision was carried in appeal, then in revision. That OP number 6 came to this honorable court before single bench directed to go in appeal. Then the OP number 6 went.
Of law.
Millers.
This contempt application is filed alleging the violation of which order?
Order dated 23/3/2023. 23/2023.
If the contempt application alleging the violation is disposed of or dropped as there is no disobedience,
yes,
can second contempt application lies?
But that order continues, Millard, because
what order continues?
Because the encroacher was never removed.
That is not there. If there is no, they have passed a reasoned order.
Yes, Millard. And against that reasoned order, they preferred an appeal.
They preferred. So what more? How the contempt lies?
I am doing with liberty to file a proper application.
Where? Here. I will not grant you a liberty.
Simply withdrawing while file proper application. Because that order
File memo. Otherwise, we'll make certain observations.
obliged notes.
What is the?
Your Lordship, this is
Where is the order sought to be reviewed?
Your Lordship, this is a transfer matter. We have received only.
Once you have inherited the asset, you must inherit the liability as well.
Yes. Today
you can't stay away from the liability. When you accepted the brief, you come ready and argue.
Yeah.
I'm asking you which order you want to review.
Order dated 12/4/2024, Your Lordship.
Yes, give us 15 seconds.
Here an IA has been filed for condonation of delay.
Oh, there is the condonation.
18 days delay.
How many days delay?
18 days delay. 18 days on.
But Milord, notice has to go
What do you have to?
Notice has to go, Milord. Private opposite parties.
Notice on a condonation.
Your Lordship.
Item number 12.
4 weeks.
My Lord, item 11. If your Lordships can kindly delete the name of Mr. Rachit Roy and Associates, Your Lordship.
Why?
My Lord, because the consent has been taken and my learned friend is appearing.
But they were the Mr. Rajit Roy was for the petitions.
I do not know whether he filed a Mogalandama.
We filed a Vakalandama.
No. The earlier one, Rajit Roy.
That I am representing. I am representing
So
Mr.
who is the advocate in record?
My Lord, as per the cause list, Mr. Rachit Roy's name is.
He was appearing as a counsel. I am asking you, Vakalandama filed on behalf of the revisionist. Who was the advocate in record?
I was Mr. Roy.
Mr.
Rachit Roy.
Your name is.
Mr. Rachit Roy is my senior. My name is Sahasranshu Saurabh, Your Lordship. Your name is Sahasranshu Saurabh. S. Saurabh.
Say that.
I'm sorry, Your Lordship.
Record his name. The advocate and record appears and submits that the petitioner has taken back the brief and with no objection from him, and therefore his name appearing in the
My Lord,
adjourned that.
item 12 seeking time for
Sorry,
filing a
service. Sorry, notice.
filing a rejoinder.
Notice on IA. 4 weeks. Yes, next.
Seeking time for filing a rejoinder.
First extension, or there is no order.
There's no order. Please.
Lord, he had already filed an IA for seeking a similar relief in the disposed of case. That order is at Annexer 7, page 27-28, my lord. 27-28.
And it is simply a repetition of the order.
Yes.
Repetition of the order.
Yes.
Same relief.
Yes, same relief.
Where can I get the copy of that IA which got disposed of on 11/7/25?
My lord, I don't have it offhand. That same relief that is.
Can I get a
yes
privilege of looking at that application?
My lord,
what is the number of the I?
that I just
that IA is I believe 10655.
Yes, ma'am.
Where is the 10655?
Yes.
Next in the petition.
Flag
B, sir.
Huh?
Flag B.
B. 1733. 107. 10. Petition. Like this is the original petition. Like this is the present petition. Oh, sir, this is the IA. This is the relief. This is the modified order. Yes. Yes, sir. How this writ lies? If the same prayer has been adjudicated upon and disposed of on merit, then how the repetition? Where is the order of disposal of this IA?
Page 27.
20?
27.
Yes. Yes, application is rejected. Then how the writ lies for the same prayer? I have seen the same prayer. Tell me.
Lord, if your lordship permits, I'll just apprise your lordship. My lord, by
We are not entering into the merit. We
My
are
lord,
simply
my lord.
on section 11.
Yes, yes, my lord.
I am just asking you how it lies. Let us go whatever the factual dispute is. Relief I have seen and the relief claimed in the petition I have seen. How it lies? Tell me, sir. Both the reliefs are one and the same. Yes. Rejoinder not necessary. It's a pure question of law. These are the facts. These are all appearing from the record. Tell me a pure question of law. Once you have prayed for the similar relief, having rejected on merit, whether you can maintain this proceeding. Why not res judicata would apply? Section 11 principle. What short date? There's a apparent on the face of the record. No factual aspect need to be gone into, only these facts. Right. Then What rejoinder you will file on rejoinder on a facts? Can you deny these facts? These are the part of the record. Nobody can dispute it.
What's your name? Sasank Sekhar Das.
So your advocate in record is the Ananya Pradhan.
Yes, madam. I have also power in this. I have also power.
You are also having a power. Yes. Tell me. How?
When a short date may be given, I'll
No,
be
sir. Are you aware of a 1978 judgment of Justice Krishna Iyer? The Arivandanam judgment.
1 week time.
Okay. Not maintainable on the face of it. And that's why there was no direction for counter affidavit or any in this no direction.
One short date.
So this bench is sitting for this matter only. What do you think? There is a disruption of 2 benches.
We have already filed filed.
From the prayer meetings. Come after 2 weeks ready.
My learned senior Mr. S.T. Das is appearing.
I have already filed a counter affidavit. We
Why
cannot give
you
it.
filed counter affidavit?
We cannot give it.
There is no dispute for on facts. It's a pure question of law, sir.
Yes, sir. We have filed. Also legally we have said it is not maintainable.
2 weeks. Anything more?
Grateful, my board.
My lord, may kindly see the last order, my lord, where my learned friends took time for implementation of the order. The lordship may kindly see order dated 8th of May. Earlier complaints affidavit has been rejected, my lord, by this honorable court. That is order dated 25 January 2024. That has been rejected. Because that affidavit was filed, they said in that affidavit, this case, Malayananda Sethi case will only govern to state government employee, not central government employee. So this honorable
Yes,
court
sir,
rejected.
what everything
Yes,
you are in
my lord,
contempt, sir.
I have detailed discussion I made, and I came to know that 2-3 things I just analyzed the court thereafter. This petitioner's father was employed with us. After his mother is come and filed away, and that we were disposed of, and a preparation was submitted on the search for ground, it was rejected. They have not challenged it. Again, the son has filed another way.
I do not know when the order has been passed. We
My lord,
want the implementation of the order.
We have implemented the order, only
but
that
it was not accepted. I noticed that particular the order of 25th of January 2024.
Yes.
The court was not very much happy and directed you to file a further compliance report.
that is that was filed in flag E, my lord.
Sir, in a contempt,
Can you take all this, please?
this case itself.
My lord, we have disposed of with a certain observation, and we have one paragraph is there about the Marananda Sati case.
I do not know. You may have. Have you gone for appeal before the Supreme Court? Have you been able to get the order of Malana and City set
It's my
aside?
instruction, we are not gone to the Supreme
If
Court.
it is not, then will you not accept if the court has said that it comes within the Malayalam city's judgment?
But my lord, Marananda Sati case was also taken into consideration as well as the other judgments, and basing on that, they have disposed of the repenation.
So you have to follow that. You can't shy away from the.
But my lord, it is a matter of suppression that previously.
Sir, in a contempt, again I am saying with all humility, in a contempt, can we revisit the order? We don't. We have to see that our order is implemented. That's all. If there is any attempt to tinker with the order, we will not tolerate.
Liable or contempt, yes, sir.
We will not.
On the last step of the Mr. Paddy,
Yes,
after that, you will take all steps to.
My lord, I have taken the steps. I asked the officials, and I have discussed with them. They are saying that we are also handicapped. We have nothing to do in this case because they are not coming in
the order.
They can't say that.
They can't. If they are handicapped, let the. Hey.
The order has been applied.
Item number 3.
Drop.
Item 3, we are filing the affidavit for compliance affidavit.
Item number
3.
Complied with?
No, man. Not complied.
It says complied. Why you are not giving it beforehand?
Already.
No, sir. Your junior is not doing it.
Sorry.
Let it produce. The LS contender files the compliance affidavit, which is taken on record. The copy whereof, semicolon, the copy whereof has been served upon the learned advocate appearing for the prisoner in court today to give him an to give him an opportunity to peruse the government therein.
Item number 4, my lord. Let's kindly have a glance at the order dated by order dated 17/4/2026. My lords directed.
May I have your lordship's attention for a minute?
Yes.
Sir, I beg to appear in these matters for the Mahanadi coalfields.
I must correct you, Mr. Attorney General. Why you use the word beg? I think you have every right to represent.
I think it's been a part of a colonial vocabulary for which we don't get.
Now we are in an independent country. Why we will?
I know that. So, just to bring to Lordship's attention, these content petitions have a long history. The litigation has a long history. But to put it short, after the Supreme Court turned down an SLP filed by Mahanadi Coalfields against a judgment of the division bench, and the division bench affirmed an earlier direction given by the collector in 2016 that in terms of the acquisition, Mahanadi Coalfields must probably comply with some compensation procedures and also give employment. But then one important aspect of the matter is the land acquisition procedure has gone into a relatively different twist now, because ever since the acquisition, the land we could never obtain possession of the land. We required the land for an immediate, project concern. And for now, till 2025, we never got possession of the land. So from 2017 onwards, we have been asking the government to denotify this because there is never a profitable acquisition for our purposes. So we have filed a writ petition which is pending before the division bench, and the matter was heard on 6th of May 2026. And this is what the court has passed, an order passed on 6th of May 2026. We have to find out whether the government can relook into the question about whether the land is really required for us at all, because it continues to be in the possession of the villagers, and we don't need that land any longer.
I understand. The thing is that when the acquisition proceeding was initiated, because you are a requiring body.
Correct.
Now, acquisition is at the behest of the state.
That's right.
When it was initiated, whether any compensation was determined.
Compensation has been paid by us, but then
whether it was deposited.
Yeah, all that is done. We have no difficulty with that.
It was under the Act 1 or it was under 2013 Fair Compensation Act?
It was under the old act, but then compensation computed.
Once the Act 1 comes into play and the compensation is deposited or paid, then the property vests into the government.
No, that's right. The problem is slightly complicated. The problem is slightly complicated in the sense the property may vest in the government, but then as long as my requirement has vanished, I no longer require this property. So the government acquired it for an ideal purpose today. I don't need this property at all. And I have not got possession of the property. I can't any longer use the property. So the state has therefore, I understand that. Therefore, they filed a writ petition. I told the division bench when the writ petition was being heard, this matter requires to be settled. Either you denotify it or you settle the matter. That's what the division bench has said on 6th of May. They have placed the matter to come up sometime in August, and meanwhile the government has been asked to find out how it can be resolved. So unless it is resolved,
I appreciate as because I was not a party to a particular main writ petition when it got disposed of.
Yes.
I was told by my brother that these points were taken at the time when the writ petition got disposed of.
No, I'm not saying no, but what happened?
Did not accept it. Even the Supreme Court did not interfere.
The Supreme Court
be replicated or
one small interjection I would like to. Yes, these questions are brought up before the division bench, but more importantly, the division bench went on the footing that the compensation has been paid under the 2013 Act. Then there is no lapsing of the acquisition. It was more persuaded by that the dimension of the matter. But the question still remains, did I get the property in my possession for a requirement? The requirement is lost. Property is not in my possession. What do I do with the property? It's not in my hands, nor I require it. Therefore, the state has to answer this question.
Passed by the division bench or
the division bench went ahead and saying, on 2016, the land acquisition collected.
Mr. Attorney General, this is in relation to a payment of the compensation.
No, we are not today. No, we are not today on the compensation issue at all. I am not on that issue at all. If in the compensation issue,
has it been paid to him?
Compensation has been paid to the government. Government will have to take care of the compensation. We have no, obligation as far as compensation is concerned. The problem is something else. As I said, we require this property for an urgent. That purpose is no longer there. I don't need this property.
Can we go into?
Your lordships can certainly go into the question, because if I don't need the property, can an acquiring authority says I will trust the property on you? They cannot say that. The property requirement has vanished.
Contempt now. Because
therefore,
is more concerned with the color of
the contempt
than anything else.
Right. No, let me say that. The contempt has two aspects. One is whether I pay the compensation or not. The answer is yes, I pay the compensation. Nobody has a question about the compensation.
There is he's disputing that he has not received.
That is with the government. We have, as far as we are concerned, we have paid the compensation. We are not in default as far as compensation is concerned.
The question of an employment.
Yes, ma'am. The question of employment. Now, Now about 700
No,
people will
that's
line
not.
up.
You have been paid compensation.
I kindly turn to
You
page.
have been paid compensation.
Not fully.
Not full. Okay.
Yes, my lord. Number
No,
one.
no, that is
And
no,
nor
that is again
the employment
No, my lord.
under the scheme.
Yes, my lord.
We have nothing to do.
the question. May I kindly
With my
turn to page
permission, employment.
one minute. Kindly turn to my reply
With my lord's
at pages.
permission, what my lord is
Look.
senior is submitting.
Yes. May I just narrate one more aspect of the matter?
We gave him reply.
If you'll also kindly turn to paragraph 4.3 of my reply, we have said 40 lakhs and odd have been paid with the government. If the government has to take over and pay to them, that's not my job.
No, that I understand. That is what we will definitely take care of that.
One more aspect today, the problem with us is now about 3 or 4 people have come here for this compensation employment. There are other about probably 500 to 600 people in the villages. Under the rehabilitation scheme, every family will have 1 or 2 more employment requests. For 700 people, I have to give employment for a land is not in my possession. It is not in my possession. I don't need the land, but I'll still give employment.
But you could have raised this point before the apex court when the SLP was there.
The apex court went.
Even a review application, I am told, has not been.
I quite see the difficulties against us. But then, since we have filed a writ petition, and the writ petition has been heard by the division bench, the division bench had asked the government to find out. I told the division bench this matter requires to be resolved through a proper mediation and conciliation, so that we know where we stand. Today, I do not know whether I need the land. I said I don't need the land. Land is not my possession. But for all that purpose, I should give employment. I am not an employment exchange.
That is what, if the order speaks so, then can a contempt
No, all that I am requesting today is
to act like a court of an appeal or to review its own order.
No, I'm not saying that. But the Lord said, just give me this in. That since the matter is coming up on 5th of August, whether the government is inclined to find a way out of this problem. As long as they don't find a way out, suppose the government says everything is closed, we don't want to open this at all, then I have to find a way out as to how the employment for 700 people. When I don't need the land, I have no requirement. I have to find an answer to this.
That you'll have to find an answer for that.
The government also needs to help me in finding an answer.
But we are more concerned with the implementation of the order.
No, therefore, all that I'm saying today is, since 6th of May, your lordships have said, keep the matter posted on 5th of August, let these content petitions be listed thereafter. We'll have better clarity on what course of action we can take. We are in a fix. We are in a real fix.
I do not want to opine or make any observation on that, but
all that I say is, please adjourn the matters beyond.
Go.
No, I kindly look at the real situation. Suppose I am directed by the court to give employment. 700 people will line up and say, give me employment. And what kind of employment? Particularly when I said, I don't have the land with me. Kindly appreciate this problem. It's a very peculiar problem arising in my experience for the first time.
That the defense is taken under the principles of impossibility.
Whatever that defense I may take and before the division bench, all that I'm saying today is please.
If you argued a particular point and this point was not really appreciated by a earlier coordinated
before a contempt
the Supreme Court, can it be reopened?
No, I'm not asking your lordship sitting in contempt to reopen it. I'm not saying that. I only, since my writ petition is being adjudicated, be heard by the division bench, and keep it after 5th of August, we will have a better clarity as to what course of action I can probably undertake. Today, I do not know what I can do. All that I'm saying is, please put it beyond 5th of August. That's all I'm requesting. Because any order passed today will completely confound the possibilities of settlement in that case. So anything your lordship may do today will completely bind my hands, and even the government may say, look here, the division bench has closed your hands, we can't do anything. So I want to keep that matter open, that's about all.
I understand, but I do not want to make any comment on that, but still,
It's
you
only a
know the
simple
law better. You know law better.
No, that's why I'm making a simple
That
request. Please,
either
please
in an
defer.
independent proceeding or a collateral proceeding, what are the scope?
So therefore, only defer the proceeding till beyond 5th of August. It's a very simple request. And between today and 5th of August, nothing is going to happen as far as employment is concerned.
With my lord's permission, only one line, man.
Fix this matter on a coming Friday after 5th.
Very well.
What
is there? 7th.
What my lord, with my lord's permission, what my lord senior is submitting, but page 60, it has already been dealt, my lord.
Oh, that's my brother who has a direct knowledge
Yes,
of
my lord.
those.
I'm not reopening all that today before this court.
Yes. Anyhow, 7th of August, we are
Very well.
keeping.
Great.
Five,
Great.
6, and 7.
All the matters, sir. Sub would have
4, 5, 6, 7.
All those matters.
Yes,
my lord.
5, 6, 7.
Since 1985, these petitions, sir.
I understand, sir. There was another line of judgments that emanates from the Calcutta High Court, and ultimately the Apex Court have decided these issues. Yes.
Great.
Lordship, it is a miscellaneous second appeal wherein the order of the Orient appeal is under challenge. So, Lordship, meanwhile, the execution has been filed by the Secretary Orera. So, I just pray, my Lord, if this matter could be taken up.
Go before the regular.
Lordship, may I come to page 51? That is the arbitration clause.
Where is the arbitration agreement? Where is that?
Lord.
Page arbitration clause. Show me.
Clause, yes, Lord.
That's an agreement.
Yes. That is at page 41, your Lordship. Page 41. This is the standard terms and condition, and the arbitration clause is at.
What is the nature of the contract?
My Lord, we are, my Lord, contractors, and the contract was given to us by Balco, the opposite party, for.
Yes.
For, my Lord, this is a foundry roof structure rehabilitation. And the work is to be executed at Jharsuguda. The clause says, my Lord, clause 28.2, your Lordship would find at page 41.
No, I am aware. Let me first find out what is the nature of the dispute, whether the dispute comes within the purview of an arbitration clause. These are the two satisfaction that has to go. That's why I'm asking you what is the nature of the contract. Show me where. This is for designing and that's an annexure 1, detailed work.
Yes, Your Lordship.
Where is annexure 1?
Annexure 1 is at page 13, 1, 3. Annexure 1 is the letter of intent, page 13. Your Lordship.
13.
Yes, Lordship.
This is the supply of the material.
Lord, is, the detailed scope.
Now, where is a section 21 notice?
Pardon?
Where is a section 21 notice?
The notice, Lord, is at page 127, annexure 9, Your Lordship.
Where?
Annexure 9, page 127.
That's a reminder too. That's a demand notice.
My lord, there's a notice for appointment of arbitrator along with our claims. Page 128, your lordship. Before that, my lord, we have also sent letters for settlement of the issues.
Where is the letter invoking the mediation?
My lord, that is at Annexure 7, your lordship.
Page
7, page 105. Before that also, my lord, section 28 notice is at Annexure 6, page 84, my lord.
I just wanted that where you invoke the mediation page.
Page 84, Annexure 6. That is the demand notice, my lord, under
That is a different one.
clause 28, invoking section clause 28, my lord, this is the demand notice.
So where is the ultimate that you wanted to settle it through mediation as provided in clause 28?
That is there.
It is really in the nature of a mid arc. So that's why I just wanted. These are the claim you have raised. Where you have
It is there, my lord. The lordship wants to see the mediation, our letter, our request for mediation.
where?
Lord. May I pray 1, 2 Passover, my lord? 1 or 2 Passover, may I pray?
What do you want?
I'm sorry, my lord. May I pray
What?
1 Passover?
Passover. I think this letter is something different. There was an earlier arbitration. I could read from the letter
My lord.
which you were referring at page 87 and page 96, paragraph 12. There was something which I find before the arbitral tribunal, the respondent contractor had claimed an amount. What is this? Go through it and then place the matter. Go through it.
My lord.
Call to.
Item number 2.
Nobody is appearing. Pass over next.
Item number 3.
Next, pass over next.
Item 4.
I freeze your lordship. The lordship's arbitration clause is at page
Yes,
22.
Yes, where is the
It's at page
arbitration agreement?
22. It's at page 22, Your Lordship. Annexure
22.
2, page 22. Right at the top, Your Lordship, para 33. All disputes relating the contract and agreement shall be settled amicably.
No.
If
So where is the attempt to amicably settle the dispute?
Your Lordships may come to Annexure 7.
Huh?
Your Lordships may come to Annexure 7.
Page.
Your Lordships, that is at page 42. Here, what has happened, Your Lordship, is we have tried our level best to request them to clear our legitimate dues. We have requested them time
Yes,
and
we
again.
wanted to see whether all these attempts have been made. Oh, this letter does not talk about the amicable settlements.
The Lordships, I may be permitted to place the case in brief, Your Lordship.
What?
Your Lordship,
No. Your oral submission that you'll have to show from the document that you have.
Lordships,
You have shown me a clause, which clause says that before you proceed for the arbitration, you'll have to just take
Your
recourse to
Lordship,
a amicable settlement.
these,
So where's the letter that we wanted? We sat, but there was no consensus. It failed.
Your Lordships, these letters were an attempt from our end to amicably settle the matter. But if Your Lordship sees their replies, they have gone on to
Where is the
force
reply?
us that Your Lordship may come to page 50 under Annexure 8. Your Lordship may see condition precedent for release of payments. I may be permitted to read that, Your Lordship. Page 50, Your Lordship. Page 50, Your Lordship, Annexure 8.
Page 50 is not an annexure. What is the letter?
It's a letter by us, Your Lordship. Your Lordship may see page
What is
50.
the date of the letter?
Date of the letter is 12/2025, Your Lordship.
Page 46.
That starts from page 46.
And it ends at 47.
Yes, Your Lordship. And their reply starts at page 48, that is Annexure 9. The relevant portion is at page 50, Your Lordship. Condition precedent for release of payments.
Where is the reply to this? Because they requisitioned you to give that particular acceptance so far as a deduction of 10% of the contract value is
So
concerned.
the reply the notice under section 11.6 read with section 21 is at annexure 10, page 51. That is dated 28/12/2025.
What is the reply to this?
Sir, they in their reply they have raised a counterclaim of rupees 10 crores as compensation on us. Since then, Your Lordship, there have been no communication.
Notice after 3 weeks.
Grateful, Your Lordship.
Item number 5.
Item number 5, my lords. I am appearing for the petitioner back.
Huh?
I am appearing for the petitioner, my lords.
No, where is the arbitration agreement?
My lords, annexure number 1. Annexure.
Clause.
My lords, clause number 15. Dispute settlement mechanism and jurisdiction.
What is the nature of the contract?
It's a leave and license agreement, my lord.
Hmm?
Leave and license agreement.
In respect of immovable property
Rental
or
property.
movable property?
Immovable property, my lords. We entered into a rented agreement.
Where is your where is your notice under section 21?
My lords. My lords, annexure 3, page number 30.
Notice.
My lords.
No, page 13 is the agreement.
Page number 30, my lords.
30?
30.
30.
Yeah.
Is the letter dated 16 January?
Yes, my lords. 16 January 2026.
Any reply?
No, my lords. There's no reply.
Notice 3 weeks.
Obliged, my lord.
Item number
arises out of a hotel being leased out to the petitioner, my lord, on a long-term lease.
Where is
page 23 is the arbitration clause.
Where is the section 21 notice?
Yes, that is at page 28. That's dated 15/1/2026. Their reply, my lord, is not to us, but a email to the petitioner's office, not to the lawyer's office. That's at page 36. They tried for a conciliation, failed, and then, my lord, we will give a notice on 21.
Notice 3 weeks.
April.
Item
There
7.
There were two opinions on that,
my lord.
Another High Court. Whether in relation to a lease, whether the arbitration is the proper mode.
Or it has to be a suit.
Because the expiration of the lease or a termination
No, my lord.
of a lease.
No, there's no dispute about that, my lord.
How I'm saying expiration of a lease or a breach of the lease terms and conditions means the forfeiture of the lease. They all come under the purview of the Transfer of Property Act.
Yes, yes.
So they say, why not section 111 take recourse to why arbitration?
No, my lord. In this case, my lord, we have merely handed over the property, my lord. And
whatever, that's a dispute.
Yes.
Yes.
Item 7.
Concession agreement. I am the concessionaire.
Where is the arbitration clause or agreement?
Yes. That is 16.3. Clause 16.3.
Page.
Page 131.
There is a notice invoking clause 16.1.
Yes, sir.
Not 16.2. 3. 16.1.
Yes.
Where is that notice?
There are letters in which we represented before the authorities that the entry fees as fixed by them, which they were not supposed to fix. Under this agreement, the entry fees, the user fees was to be fixed by the concessionaire. But the government, what they did, they fixed an amount that is 50 rupees. So we said that 50 rupees is not sufficient.
No,
The
that is, we are not, I am not concerned with the,
Yes,
with
no,
this.
collector-
I am just concerned with the adherence of those
Yes, Your
conditions
Lordship.
which you
We
have agreed.
we
So
represent
first
them.
thing is the first 16.1 talks about that you'll have to first take steps for
Yes,
amicable
yes, sir.
settlement.
Yes, Your Lordship.
Where do I get it?
Yes, sir.
That you have taken
I'm
records.
I'm just that is my letter 8/5/2003 under clause under annexed, Your Lordship.
Page.
And that is 154, 156 page, annexure 9.
154 is issued by
154
is issued by the collector.
No, ourselves. The collector has written that.
So where is your letter?
My letters are annexure 8, 152, 153.
Yes, then
the collector replied that yes, it is a recommendation to the secretary that yes, it has to be high, and he fixed it for 150 rupees. That is 154 annexure 9. And more or less also he recommended to cross subsidize it.
So there was then
Then the matter was taken up on several meetings. It was held that yes, we will take up this matter. We'll cross subsidize it. We'll cross subsidize it. Then they later on they fixed it to 100 rupees. In spite of the collector having recommended for 150 rupees, where our claim was for 350 rupees, but the collector recommended for 150 rupees, they fixed it for 100 rupees. But that 100 rupees was also not paid to us.
who are the contracting parties?
That is Secretary Transport, TAMDA.
Where do I get it? The agreement?
Concession agreement, Your Lordship.
Where is that?
That is Annexure 3, page 33 to 139. Page 33.
It's a tripartite agreement.
Yes, sir.
Then what happened?
Then we have issued a section 21 notice. It's under page 205
Against?
the government.
Was the government a party?
But
to the contract?
Yes, sir, Lordship.
Where is that? Come to page 37. Yes. Was he a party to the contract?
Yes, sir. Culture Angul Meramundri
That's the another independent body.
Yes, a
Statutory
statutory body
So,
constituted under Orissa Development Authorities Act.
correct. So statutory body has an independent authority.
Yes,
You're
sir.
talking about government.
Yes, sir.
Where is the government of Odisha?
Page 38.
It shows that they are the party to it.
Yes, page 38. First paragraph. The
Yeah,
government.
that is a different. That's their initiative, but
Yes.
it has been entrusted to them.
Yes.
So how can you?
And all my communications.
How can
with
the
principal
grievance is
secretary-
against the government?
Yes, Your Lordship.
How can you? He's not a party to the contract.
Because the collector is the vice chairman of TAMDA.
You can have a grievance against this
TAMDA.
TAMDA.
Yes,
You
that
can
he-
have, but
they-
you
they
can't have a
also-
grievance against the government.
Because the vice collectors is the vice chairman of TAMDA. So the collector representing the government. So the collector recommended to the secretary, government of Orissa under the transport department for this cross subsidy. And the government also.
There is a gulf of difference between a writ petition which you are filing before the court and an arbitration application.
Yes, sir.
How can you make a first party, second a party,
B.
third a party,
Yes.
four a party?
Lordship.
How can you make
paragraph B.
1 to 5 as a party?
The paragraph B. The government of Orissa acting through the grantor is intending to develop the various bus terminals in the state.
Oh, that is a different issue. So, a parent agreement is given. The parent contract is given to a particular person. The person has entered into another contract with a third party. Now, this dispute arose between that second and third party. Then parent party will be held liable for that. I'm asking you, under the arbitration act, it is the party to the contract who are bound by it. If
Yes,
somebody
yes,
who is
sir.
not they have not signed it, the government of Odisha is not a party to the contract. It is a statutory body which is the TAMDA. It is a HON'BLE bus terminal company and is the Milan developers. They are the three parties. How can you make them
because the
opposite party number 1 to 5?
My humble submission in that respect would be TAMDA is a public corporate under the government, and the collector is the vice chairman of TAMDA.
I'm simply asking you, sir, very simple question.
Yes, sir.
That even if one of the director is an ex officio nominee of the government, does it mean that the company becomes a government company?
No, it has been constituted in that manner.
I'm simply asking the question to you.
With the government's aid and help, that body has been, TAMDA has been constituted, and the governing
This is under the statute. Like, say for a Cuttack Municipal Corporation, it is constituted under the Cuttack Municipal Corporation Act.
Yes, sir.
So government of Odisha will be a party because it is an independent statutory body responsible to answer all his actions.
Because the government,
and in a contractual field, you'll have to make them liable.
In that respect, my submission would be government empowered TAMDA. Government gave entire responsibility to TAMDA.
Show me a law. I must say, I do not know.
Execute this contract. That is why the government name appears each and everywhere.
that yes,
Sir,
and
any township which the government has taken out, but there is a statutory authority or a statutory body which is there to take care of that. That does not mean, because they have their own independent existence, perpetual succession rights, as you find. But it does not mean that the government is impliedly or tacitly included therein.
and
Even a group of companies,
I understand
companies, the notion has been doubted
Lambda
by
bylaw
the Supreme
says,
Court.
Lambda bylaw says that it has been constituted for the purpose of by the government. There is a resolution. Lambda has been
No, sir.
There is
an act which was passed by the Assembly, which is the birth of TAMDA.
Yes, Your Lord.
So it is under the statute. It's an independent body.
Independent body
having its perpetual succession.
Yes, Your Lordship. But for this
so how the
purpose,
government becomes a party to the contract? It is the TAMDA who is responsible.
my lord, for this purpose, for developing this
No,
bus
sir.
terminal,
I do not agree. Then I am going to dismiss this.
then Lord, give me one time. I'll file an additional affidavit.
What additional affidavit?
That how the government
argue how the government
and the communication.
Tell me, show me one judgment.
I will produce that, sir.
Not a single judgment.
My lord, no. How the government has been made a
Cox
party.
and King's judgment of the Supreme Court does not really, though, say about the group of companies, some companies which are not directly coming within the purview of a contract, but by virtue of a group of companies, they can be said to be a part of that particular contract. These are all still doubted somewhere. That is what you wanted to make a notion. I do not agree with that.
No, my lord, I will just
Sorry,
place before the honorable
apex
court.
court has not accepted that.
No, I will just place the facts before the honorable court for consideration.
What is a fact? Fact is very clear. The government decided they wanted to establish something. There is an act which is passed by the Assembly. By virtue of that act, an authority sees its birth. Authority is a statutory authority. Agreement was entered into by that statutory authority.
Yes, fine.
Whether the government is impliedly a part of the contract. Just show me the law. Let me learn.
No, Your Lordship.
Then why you have made the opposite party number 1 to 5 a party in this agreement, in this petition under section 11?
Because they also subsequently, the collector communicated to us and the secretary also communicated to us.
We are concerned with
parties.
There is a gulf of difference between a right emanating from a statute, I mean the constitutional right, and a right which is restricted to a contract.
Yes, sir. Yes.
If your right emanates from a contract.
Yes, sir.
Then
that is how the government stepped in, because
the government is no.
I will place the facts next week.
Facts are
no. I will place the affidavit on affidavit that how the government has been made a party. Next week, next week, first sitting, let this case come up. In the meantime, I'll file the. Mobilize you.
Yes.
But the arbitration clause is at page 21. Towards the bottom.
Just.
So this is a part of a work.
Let me do it.
Yes.
Yes. And
this is a work.
What is the nature of the contract?
My lord, this is the work order for fabrication and erection of a cold storage shed and incidental work.
Where is a section 21 notice?
My lord, that my lords will find at Annexure 9. Lord, there are in fact would say
Annexure
9.
Page.
Yes, madam. Page 45. This is by the respondent, my lord.
Yes.
And then this was refused by the petitioner through Annexure 10, where petitioner also proposed certain names. Then this was also disagreed at Annexure 11, my lord, will find.
Service. 3 weeks.
Item 9.
Please, Your Lordship. Your Lordship, this is a slum redevelopment project.
What?
This is the contract is in relation to a slum redevelopment project. The arbitration clause is at page 24 of my petition, clause 8.
Yes, where is the dispute?
Your Lordship, my notice invoking arbitrations annexure 3 at page 26. And my list of claims is at page 28. Paragraph 8.
Where is the proof of service of the notice?
Your Lordship, the proof of service has not been annexed, but I can place that on record.
How do I take it that it has been served?
Your Lordship may give me 2 days' time. I'll place that on record, the proof of service.
Adjourn for 2 weeks. Next.
Item 10.
Item 10, may it please, my lords. Annexure 1, page 27 is the arbitration clause, clause 24, my lords. Coal transportation agreement.
Yes, where is a
Annexure 10,
where
page
is the attempt for
attempt, my
amicable
lords, there is
settlement?
no letter saying so that for amicable settlement, but there are numerous letters requesting them for release of the overdues, my lords.
Yes.
And
whether there was any response to
no,
your
my lords, there were
notice
no
under section
responses
50?
to all the letters, even the last letter which was for invoking the arbitration clause at Annexure 10, 164, my lords. There have been no responses.
Where you have made an averment that all the attempt for settlement fails in the petition.
There was no endeavor for settlement, my lords.
When you
But
have to say that we have been
all the
these
letters
are the preconditions.
at 117, my lords, all the letters we have sent for clearing of the dues have gone unnoticed, my lords. At page 120.
No, I've seen the language is different. Yes.
Yes, my lords.
Notice 3 weeks.
Grateful, my lords.
Sorry, my lord. I've got instructions to appear in this matter, my lord.
Except waive the notice.
My lord. If they can be given, I'll take 3 weeks I'll file a reply.
But since you are a young lawyer, I must suggest that's not he appears and waives the service of notice.
Item 11. Item 11 also I've got instructions.
The arbitration clause at clause number 28, page 35. Clause number 28, governing law and dispute resolution.
What is the nature of the contract?
The transportation of coal.
Oh. Where is a section 21 notice raising a dispute?
Annexure 7 series, page 65.
Any reply?
No reply.
Copy.
Well,
served or not served?
No, madam, not served.
By tomorrow. By tomorrow I'll solve.
Please, my lord. But the arbitration clause, my lord, will find on page 18, which is settlement of dispute mechanism, my lord. It is a 4-tier system, my lord. A3, page 18, my lord, 3.5, sir. So it is 3-tier system.
Yes, that is
First
one is to approach the engineer who will
Engineer,
be done in
then
30 days.
superintending, yes, my lord. Then chief engineer, and then the secretary.
Appeal to superintending engineer.
My lord.
Within 30
then
days.
Chief engineer.
And then if it is not, then a chief engineer.
Yes, my lord. Then last is the secretary.
And the chief approach the principal secretary or secretary.
Lord, we approached the additional secretary, my lord. So who was in the charge at the relevant time? My lord,
Yes.
Next 4 is the first compliance, which is on page 19 to superintending engineer, because there was no engineer or executive engineer.
Yes.
The definition says engineer means executive engineer, and executive engineer post was not created. So my lord, we approached superintending engineer twice. First on 28/11/2023, which is page 19, annexure 4.
Yes.
And then my lord, annexure 5, page 25, again to superintending engineer.
Yes.
Page annexure 5, page 25, 17 January 2020.
Yes, as I've seen. Yes.
And my lord, annexure 6, page 31. The chief engineer, the third entire.
Yes.
Then my lord, the fourth is 84, annexure 9.
Page
84, my lord. Development Commissioner come additional chief secretary. He is the last in this series. Then lastly, Lord, we sent him the notice under 21, which is
21 notice.
Annexure 10, my lord.
Page
87, my lord. 2nd of June 2020. 2nd of February 2026.
Any response?
Not yet, Lord. In fact, I think they are.
Where is the proof of service?
Lord, proof we have not placed on record, Lord. Request Lord, give them 1 week notice if they have any objection.
No, that I understand. Whether it has actually been sent or.
Has been sent, my lord. Nothing, because we have received replies also. So far, other authorities are concerned, we have replies.
That's why I asked, any response to this notice? Any response?
No, this notice, no response. 21 notice, no response. But my representations to other authorities, there are response.
No, that I understand.
My lord.
But I'll have to show the proof of service, whether it is sent by email or it is sent by the post, whatever.
Let's say let them serve a copy. They have not served a copy yet.
You are representing the opposite party.
Only sole party, not the government.
The state of Orissa. Service, who is appearing? Who is then affect the service? Mr. The party is appearing for the opposite party. How soon you can serve the copy of the application?
But by tomorrow I will serve them. I undertake. My briefing counsel, I'm so sorry, my lord.
File your opposition.
I will do.
Yes, rejoinder 1 week thereafter, matter to appear after.
Item 13.
Deeply obliged.
Yes, legal attorney. This appeal is arising out of a master bill which has been remanded for fresh trial of the suit.
What?
The present appeal against the order of remand passed by the First Appellate Court under Annexure 1, page 11. The present appellants are plaintiffs. Filed the suit for demarcation and permanent injunction.
Suit for partition.
Suit for permanent injunction and demarcation. The land recorded in the name of the
without permanent injunction.
Permanent injunction to restrain the defendants not to interfere in the possession of the plaintiff. The land recorded in the name of the plaintiffs. Defendants filed a counterclaim stating that the plaintiff is the owner of another piece of land. They have made a schedule and objected the prayer of the plaintiff with regard to permanent injunction. Both the suit
they claimed for any right in the property. Which
they instead of making any claim in their favor, they claimed that the plaintiff is the owner of other property, therefore right title interest of the plaintiff may be declared in respect of other land. The plaintiff suit.
How can it be a counterclaim?
That's why the suit has been dismissed, and a counterclaim has been dismissed by the trial court. Both the plaintiff and defendant prefer two appeals. In the appellate court hold that the plaintiff's suit is maintainable since the land has been recorded in the settlement record of right and a separate map has been prepared, suit is maintainable. So far as the consideration of a counterclaim, the learned appellate court misled with regard to a lot number of property. The lot in respect of lot number 2 property, there was no finding by the trial court. So far as the lot number 1 property in claim the defendant raised, that is the belongs to plaintiff. So far as the lot number 2 property, there is no finding as observed by the learned appellate court and remanded matter.
So limited remand. It is limited remand in respect to lot number 2.
Lot number 2. But in fact, there is no lot number 2 in the counterclaim. Lot number 2.
No. When you filed a claim, you must have appended. We call it a schedule. The where the property is described.
I have annexed that plaint. That is the remand not on the basis of plaint schedule property. Remand on the basis of lot number 2 of the counterclaim schedule property.
And there is no
lot number 2 property. The defendant wants to introduce lot number 2 property by way of amendment, which has been rejected.
Serve the notice.
Please, Your Lordship, I appear for the petitioner in this matter. Lordship, at the outset, if I may point out to the Honorable Court, on 5th December 25, the Honorable Court had required us to place on record the signed copy of the agreement, which we have now placed on record under the cover of the additional affidavit dated 25th January 2026. Your Lordship, for a moment, kindly have that. Additional affidavit filed by the petitioner.
Oh, yes.
Yes. Lordship, the only reason Lordship had asked for this because the previous agreement that was placed on record was unsigned. So Lordship wanted to see whether the contract has been signed by the parties. Lordship will see at page 6 of this additional affidavit, it is a signed copy of the contract. Mithila Construction, which is the respondent before your Lordships today. In this contract, if your Lordship will kindly see the arbitration clause at running page 12 is the arbitration clause.
Yes.
It is the at the bottom second last paragraph, arbitration, under the head arbitration. This contract shall be construed, governed, and enforced in accordance with the.
Then, where is the section 21 notice?
Yes, Your Lordship. The section 21 notice is at running page 57 of the petition that was filed, Your Lordship. Your Lordship may kindly have that. Page 57. Subject written is notice invoking arbitration, and it is shown to be delivered at running page 66, Your Lordship. The tracking starts at 65, and at 66, Your Lordship will kindly see status is shown to be delivered.
60?
66 of the petition, Your Lordship, of the petition.
I understand.
Yes.
Oh, yes.
Yes. So this has been, I have not received any response to this, Your Lordship.
Service. 3 weeks.
Item 15.
Yes, my lord, I appear for the petitioner, my lord. My lord, this matter was taken up on 13th of March, my lord, last occasion. Thereafter, my lord, there was a direction for the parties to amicably settle. That has not been happening, my lord. So right now, my lord, I pray for an appointment of an arbitrator, my lord.
Yes.
Lordship, I'm appearing for the opposite party, Your Lordship.
Yes.
I'm appearing for the opposite party, Your Lordship. Your
Hmm.
Lordship, we are agreeing for the appointment. Your Lordship, may I issue direction, Your Lordship. Your Lordship, may I issue direction, Your Lordship, and appoint an arbitrator, Your Lordship. As plus clause
Where is
20.6.
Yes, it's at page number. Yes, my lord, it's at page 820, my lord.
21.
820, my lord. 820, clause 20.6.
I'm asking, petition contains so much of voluminous paper. 821.
My lord, it's an agreement, my lord, with the government. All the GCC agreements, all these agreements are annexed here. That's why, my lord.
Total amount of claim?
My lord, near about 99 crores, my lord.
100 crores.
99 crores, 17 lakhs, my lord.
Where is the arbitration clause? 100 and,
Yes.
sorry, 820?
Yeah, 820, my lord.
The arbitration completion. India. Panel. Any name common by both of you?
Your Lordship, I appoint an arbitrator because Your Lordship, we are before Your Lordships because we could not agree on a one. Any
Both of you agree to any name?
My lord, if my lord, my friend agrees, Justice Shivagnam.
Just Ashok Ganguly retired. No, Your Lordship, I would request Your Lordship to pass an order with regard to that.
As my lordship pleases.
एक बड़ा बोल दीजिए बस.
Any former judge of this Honorable High Court, Your Lordship. Justice I. Manki.
Where, what would be the seat of the arbitration?
Yes,
Minister is
from Calcutta, my lord.
incorporated.
In Calcutta, Your Lordship, I would suggest maybe in Delhi, Your Lordship.
And the opposite party
is in Odisha.
Is
in Bhubaneswar and
the water corporation is that is here.
Yes, correct. Yes,
This
ma'am.
party is of Calcutta.
Calcutta.
So
Yes,
the
ma'am.
neutral venue has to be considered.
Yes, sir.
So a third person who is not connected with Odisha and Calcutta has to be chosen.
Hello. कोलकाता घूमने के लिए ठीक है मैंने बोल दिया.
Much obliged, my lord.
Because I have no issues on Justice Sivagyanam, but since he holds the position of a Chief Justice of Calcutta,
Yes, my lord. My lord, the jurisdiction is of Odisha, my lord. The my lord can appoint from Odisha also. Anyone.
We agree to that. Your Lordship. We have no issues. Here.
No issues. Justice Shivagnam is neutral, my lord. He is not from Calcutta, at least.
No, I know he's from.
Yes, my lord.
He's from Madras.
Yes, my lord. So if my friend agrees, we can do that, my lord.
Yes.
The seat of arbitration may be Odisha, my lord.
Odisha, Your Lordship, any former judge from this Honorable High Court, Your Lordship, we have no issues with that. With the consent of the other party.
No, he has nothing. Any retired judge has to be appointed as.
Yes, sir.
So you can't have any doubts on that.
No, Your Lordship, absolutely.
So why you want it only on Odisha?
No, Your Lordship, since the seat of the application
So that will come.
Yes, sir.
He has to come and attend it.
Yes, sir.
I do not know whether he is holding any position or post. I do not know. Let me ascertain and then.
Yes. Obliged. Much.
You just give it to me. So we just ascertain whether it is there or not. So
Come for consideration of condonation of delay.
service
Notice.
condonation notice.
Item 17.
Please.
Lord, 11.6 application, my lord. There are three opposite parties, my lord. The office noting is saying that so far as OP number 2 and 3 are concerned, my lord, they have accepted the notice and they have not appeared yet. But may I submit, my lord, the matter may be referred to the arbitration. Let the arbitrator send the notice and then, Lord, the matter, the arbitration was filed in the year 20.
How this has come?
Application of
that is what I left.
Yes, address left.
So left cannot be a good service.
Yeah. The left, my lord, the company that the OP number 1 is the company, my lord. The company has closed its business in annex, the opposite part number 1. But I am talking about the OP number 2 and 3, my lord. They are the directors and they have received the notice and they have not appeared.
Where is a OT that 2 and 3 received it?
25th of June 20. 15th of June, 15th of May 2020. 15th of May 2020.
What it says? 2 and 3 also. What is the dispute?
But dispute, it's a share purchase agreement, my lord. Main dispute between the petitioner company and the OP number 2 and 3.
Party.
The dispute between the.
How much is
Lord,
the value?
Slightly above 1 crore. Lord, in our notice, my lord, I have quantified it to be, my lord, 1 crore 34 lakhs. Page 39.
No, arbitration. First thing is the agreement.
Well, Lord, page 19.
Page 12 is a share purchase agreement.
Lots of well. Clause number 6.2. Page 19.
Yes.
Lord, B. If any dispute arises between the seller and the purchaser during the subsistence of this agreement or thereafter, in connection with the validity, interpretation,
Yes.
my lord.
And
then I sent the notice.
Location is?
My lord, page 36, annexure 2. 10th of Lord, September 2020.
Where is?
The service has page 42, my lord. Email.
No response.
No response.
Okay.
Item number 18.
Please, your lordship. Arbitration clause is at page 13, clause 20.
No, there was already a direction for notice.
Yes, notice.
Somebody appears, Mr. S. Mahapatru. Can you give a notice? Because if he is appearing, then
No, he has appeared, but he has not filed wakalatnama. That is the office note. Last occasion, he said that he will.
Can you give a notice to him to appear?
I don't.
You don't know Mr. S. Mahapatru.
There were several S. Mahapatras.
Yeah. Please.
Item 19.
But the arbitration agreement and clauses is similar. Page 109 in process.
Page
109, clause 16 and 16A, lordship.
109.
Yes, 109.
Yes.
The settlement of disputes. Lord, this arising from the construction of building work and dispute was arose between the parties. Lord. It is incumbent upon the contractor to avoid litigation and dispute during the course of execution. However, if such disputes take place between
where is the dispute? You refer to area GM or a GM?
Yes, Lord. That is annexure, your lordship.
Would you like to file any affidavit? Or
Already, Lord, counter they says there is a valid arbitration clause. Lord, your lordship, counter paragraph 10 and 11, 11, 12, they say there is a dispute to be resolved through arbitration and there is no claim settlement. But there is they are disputing the
16A was complied with, he appeared, they gave their sentences and company that there is no claim as far as.
No, that is the difference.
Thereafter, he gave earlier notice and.
So according to you, everything is complied with. Now he is agreed, so it has to be adjudicated by an arbitrator. So what is the total claim of?
They are about 3.5 to 4 crores because they are not quantified in total. Whatever I was
3 to 4 crores. In between 3 to 4 crores, Lord, including interest. So any Lord, someone.
Both of you agree.
Dr. A.K. Mishra, retired Justice Dr. A.K. Mishra.
No, Milord, I am saying Justice
Or
C.R.
Justice A.K. Rath.
Dr.
A.K. Rath.
A.K. Roth, your lordship.
Dr. A.K. Mishra or Dr. A.K. Rath?
A.K. Roth may be. Dr. A.K. Roth will be available.
Item 20.
Lordship is appointed
Just
after
after 20 or different? Yes, please.
No.
No.
Lordship appointed A.K. Mishra or A.K. Rath?
Roth. Justice Roth. Both of you agrees.
Akshay Kumar Roth. Dr. Akshay Kumar.
The last occasion, I am for the petitioner. In the last
Notice was directed. Has
Yes.
it been served?
Yes, my lord, they have issued also, they have given the objection.
You like to file your rejoinder?
No, my lord, we can appoint, my lord's appointment of arbitrator.
What, they have agreed?
Here the see, from the same contract, one arbitration tribunal has been constituted from the resolution of disputes. How the second arbitration will happen? From the same contract, from the same part. Earlier that the dispute, they have filed an application before this honorable court. By order letter 1/9/2023, arbitration tribunal is constituted headed by Justice S.C. Parikh. Now that is in hearing stage.
No,
From
we have
thereafter-
not filed. We have not filed, my lord.
Who have filed? You have filed.
No, I am for Brahmini developers, my lord. I have not filed.
It is just with construction.
No.
No. Which one?
21, the last one.
No, it's a Brahmini Developers Private Limited.
Yes, my lord. I have not filed anything before this one level.
You are appearing in.
Yes, I am also appearing for this case now. Unfortunately, madam, I will miss the file. Next week.
No, you are handling so much voluminous breed. You jumbled up. Counter is filed.
Yes, my lord.
Yes,
Counter-
What they have said?
My lord, they are disputing the claims what we have made.
That is one thing. That's why we want it. But are they disputing any arbitration agreement?
No, no.
Or they are disputing this clause or
No,
something?
no, my
Nothing.
lord. No.
So what is this? The dispute you may deny, go before the arbitrator and deny.
Let it next week.
My lord,
The file is not available.
It was filed in
Next week is not available. Handicap.
But I
Please
can
give me
provide.
19. Give me a 19 file.
Item 19.
No, don't call it. Give me a.
Sir.
Huh?
Sorry for that, my lord, because this is the.
Why don't you give me a type copy?
I will give you a type copy.
Give a type copy next week.
Next week, my lord. And my lord, what my lord has asked the question to her, that is my claim, my lord. Claim I have inserted the decision of different high court. That page 91.
Oh,
And
that
so-
I find from the. I did not know there was an arbitral tribunal. Arbitral tribunal decided. I just asked.
That's where we have rely upon the judgment of the Calcutta High Court, my lord. At page 95, it is started.
That's all. Is coming
Item-
next week.
Item 2,
Nobody is.
item number 3.
Nobody is.
Next two.
Huh.